Today, I'm very pleased to introduce what I think is one of the icons in intellectual property law within the United States. We'll have a fireside chat where we'll pull out his life story, but it sort of starts at 26, gets a law degree, 25. I think at 26, he quits to start his own firm. This year, he just moved all 450 people into a brand new office in DC and is the fourth largest intellectual property firm in the nation. He's worked with some of the greatest innovators in his time, and he knows not only a lot about people, about innovation, and also about strategy. And he's going to share with you how to build a playbook for intellectual property in the new global world. I'd like to introduce Rob Sterne.
So welcome. It's a great honor to be here. I went to school up the road. You may have heard of it, Tufts University. And the opportunity to speak in this famous room is just something really special for me. For those of you who are history buffs, one of the most highly regarded Supreme Court justices of all times is Justice Oliver Wendell Holmes, who was severely injured in the Civil War and undoubtedly was on this stage at some point when he was at Harvard. So it's a great pleasure to be in such a great venue. I want to talk to you today about how to use intellectual property for your startup, in your career. How to use intellectual property because it's the law of the products of the mind. It's the law that will protect all your creativity or not, depending on how you use it and how your competitors use it against you and your enterprise. How many people here are seriously thinking after college of having a startup? Anybody want to raise their hand? I love you all. So let's talk about why you need to know this regardless of what you're going to do. So let's go through some of the basic areas of intellectual property law quickly, because I want to talk about some of the most cutting-edge issues right now in intellectual property law, which, of course, as we all know, is artificial intelligence. So we're going to get to AI later, but let's go through some of the basics first. So here we have Article 1, Section 8, Clause 8 of the United States Constitution. You may not have ever read the U.S. Constitution in detail. Frankly, I didn't until I was, after 5 years of engineering school, went to law school, and I was one of 2 engineers out of 220 people at my law school. So here's our Section 8. The Congress shall have the power to promote the progress of science and useful arts, by the way, every word matters, by securing, we'll talk about that for a second, for limited times, because there's a duration that your intellectual property is protected for you, to authors. So every time you write an email, you're an author. Every time you take a selfie, you're an author. Question is, if you feed something through AI, are you an author? And the answer is probably not. So we'll talk about that. And inventors. So notice the distinction between authors and inventors. Thomas Jefferson, of course, wrote this with James Madison as his scribe and genius drafter. So Jefferson, as many of you know, was an inventor and an author. The exclusive, underline exclusive, meaning others can't do it, right, it's a right. It's the only place in the Constitution, except in the Bill of Rights, where the word right is used. Important. To their respective writings and discoveries. Writings and discoveries. Our inventions, discoveries, our authorship, writings. This is what intellectual property lawyers start with as the basis. We were the first country in the world to have this in their constitution. We were the leaders in intellectual property law. So a few things, and you'll get this slide deck so you don't have to take any notes. The way it works in the U.S. government is you have statutes, and then those statutes are limited by the US code, federal code, which is listed here for patents. So you have a statute for patents, 35 USC, United States Code, and then 37 CFR, Code for Federal Register, which is the implementation rules for what is in the statute. Here's the jurisdiction of the courts and of the various federal agencies. So you have the Patent Office and Trademark Office for all of you who are starting businesses and you want to protect your brand, you want to protect your name, your likeness. That's trademarks. Patents are for inventions, as we'll discuss quickly, and then get into detail. And then, of course, you have the Copyright Office as well, which is a separate agency. You also have the district courts. There are like 94 district courts throughout the United States. We have a district court here in Boston, and they hear all patent cases. You don't have a specialized court for patent or trademark cases or copyright cases. And then you have this organization in Washington called the International Trade Commission, which is used to exclude infringing goods and services from around the world. Here are the buildings. You have the US Supreme Court there on the bottom, on your bottom left. The Patent Office, the building you see up there on your left, top left, is the Federal Circuit, which is where all the patent and trademark cases go. You have the International Trade Commission in the middle on the top. You have the US Patent and Trademark Office on your right at the top. And then, of course, the Copyright Office is in the bottom right. So when you're in Washington, you might even want to stop by and see some of this, because it's interesting for all you entrepreneurs to know that these are the federal agencies that protect you. So we have utility patents. That covers patents in terms of their structure of inventions, their operation. This is where most patents are. For example, if you take an iPhone, there might be, pick a number, 200,000 utility patents that cover the apps, the internal operation of the iPhone, the display, whatever, in a single product. In a drug situation, in contrast, you may only have 2 or 3 patents covering that particular small molecule or whatever. So technology changes how the intellectual property of patents is applied and used. So you need to know how your technology, if you're in a technology startup, is going to be treated by the US patent system and patent systems around the world, because each country has its own intellectual property system. There are treaties between countries that have existed for over 100 years, where if you get rights in the United States, you can try to get corresponding rights, say, in the European Union, in the UK, in Japan, China, wherever. So let's take a look at some interesting patents I decided to show you. Steve Jobs, I met him, he tried to hire me, he negotiated against me. Brilliant guy, weird guy, really weird guy. I mean, when we were negotiating, I was sitting next to one other person. And for those of you who've read Isaacson's book about him, you'll know that he had a Japanese guru who taught him how to stare you down. So after about 10 minutes of being stared at completely without blinking, I'm unnerved. But what did that teach me? The reason Steve Jobs was so successful, not a very nice guy, by the way, because I worked for many of his people, but the reason he was so successful, in my opinion, was he was laser focused on what he was trying to achieve. And I know for a fact that when he came back into Apple and told them, we're going to have this thing called a cell phone without keys, his design team, which I've done a lot of work with, told me, they said, impossible. He said, well, if you can't do it, I'm going outside of the company. We're going to do it. So the important point to know is your mindset as an innovator is something we're going to talk about later if we have time, because I've seen all types. There's not one type that works best. But the important thing that they all seem to have is this focus, this unswerving focus. Here's one of his patents. This is a utility patent. Nobel Prize. This is a Nobel Prize patent, right? Big fight, by the way, with your university between this group. Disclaimer. But she won the Nobel Prize on this. You may have heard of Jeff Bezos. This is one of his original patents. Back then, of course, his one-click patent was famous. But of course, he was a tiny little company at the time. Here's basic Bluetooth patent. Remember, there's over 11 million US patents issued, been in chronological order since the 1840s. And here's one that deals with HIV. So these are just representative examples. You can go up, look these up, read them. Might be fun to spend an hour, look up each one of these patents, go through it, see how it's organized, what's in it, what's not in it. It's a good idea for all of you to start familiarizing yourself at a very high level as to what really is a US patent in terms of its print. So let's talk about design patents. Many people don't realize that the ornamental aspects of a design can be protected by a separate type of protection. And this is not just in the United States, but it's used all over the world, particularly in Europe. So if you have a product configuration or a graphical user interface, for example, or things like that, that is ornamental and not utilitarian, because remember, utility patents cover utility aspects, and designs are covering the ornamental aspects, you can get what is called a design patent. So here's the Statue of Liberty covered by a design patent. Here's the Coke bottle. Here is one of our action toys. Here's the iPhone. So what's the story behind this? Well, my law firm did this. I didn't do it. Tracy Durkin, one of my partners, is one of the international recognized experts of design patents. And when Apple decided to go after Samsung for the iPhone, we had filed these design patents on just the outer configuration of this device with no keys and with the graphical interface displaying apps. In the final analysis at the US Supreme Court, it was these patents that became the patents that were most successful in the Samsung battle. So here is the graphical user interface patent for Apple. For those of you who are into Hermes bags, this is a famous design patent that I thought would be fun to see. And here we have the vaping craze. They obtained design patents for the pods for vaping. By the way, I represented Juul. I don't think it's a good idea to vape. It's a little disclaimer. Trademarks. Again, at the beginning, I mentioned that you need to be very concerned about your brand. I don't care what your startup is doing, what your business is doing. You do not want to have to change the name of your company or your product line or your product, because if you do that, the customers think you've either gone out of business or discontinued or whatever. So trademarks are very important, and many people just pick a name and then they start using the name, and then 2 or 3 years later, they discover they can't use the name, and now they've built all this goodwill around that name, or that mark as it's called, and then they have to abandon the mark, maybe after a legal fight. So the important takeaway here is make sure the name or mark that you're going to use is really legally available for you for your particular goods and services. So here is a trademark on one of my clients, one of our clients that I've represented that has had incredible success. And yesterday we were doing some taping on this story, the bunch of balloons story. Many of you may know that this is the #1 selling toy in the United States for the last 5 years. Hundreds of millions of dollars of sales. It's a device where if you screw it on a nib or a hose bib, you can fill all those balloons in about 10 seconds, because as they fill up, they get heavy, they slide off those nibs, those rods that you see, and there's little O-rings that collapse around the neck of the balloon and automatically seals the water balloon. And as you can imagine, if you've ever tried to fill a water balloon by yourself with a hose or something, you have to tie it off, and it drives most of us crazy. So this toy here is actually, this is the trademark bunch of balloons that is registered separate from the utility patent that was obtained, that was used to prevent copiers of this incredibly successful toy. So here we have the trademark of the Apple Store, the Nike swoosh, Facebook's, you may have heard of Facebook, may have had some relationship to this university. Again, we're back with our friends at Hermes. So anyway, what I'm trying to say is trademarks are very important. Probably applies to more of you in here than either designs or utility patents. So let's talk about copyrights. We're all authors. We've been authors our entire life. Every time we fix anything in a tangible medium of expression, whether we write it, we film it, we record it, whatever, we draw it, we have created a work of authorship. And the moment we fix it in what is called a tangible medium of expression, which can be a piece of paper, electronic, whatever, that becomes instantly a protectable copyright. You don't have to register it. You register it if you want to go to federal court, but you are creating stuff right now with your computers that is copyrightable to you. You are the author. And so if you hire, say, a photographer or a web designer to do your web design or your photograph, and you don't get an assignment of rights from that individual to you, even though you commissioned them, told them what to do, paid them what to do, you do not own that copyright. And this is a very common problem with many companies. They use third parties, not employees, but they use third parties to develop stuff, and they don't obtain the written assignment with the magic words that you have to use to transfer the copyright rights of what you had created on your instruction with your money back to your enterprise. Very important point. So here we go. Here's a famous Andy Warhol copyright, and as you know, the Andy Warhol Foundation has been incredibly litigious protecting Warhol's works, particularly in the area of AI, for example. Here we have airline. Certain products, like the Batmobile, have been copyrighted. Remember, copyright protects, and I didn't say this already, protects the manner of expression, not the underlying idea. And that's an important point, because where does the manner of expression end and the underlying idea appear? Because underlying ideas are not copyrightable. You can't use copyright to protect the idea of a novel. But the actual novel can be protected by copyright. It's just that the storyline is the underlying idea, and that is not protectable. And so there have been many, many famous copyright cases trying to determine whether something is on the line of protection, manner of expression, versus being on the line, over the line in the underlying idea. Jewelry oftentimes is copyrighted, but again, not the underlying idea of the jewelry, but the actual way it was put together. And then, of course, you have certain patterns, fabric patterns, paintings, and so forth that are all copyrighted. So here's an example of that. And then we have, this is a game that's copyrighted. So, we'll talk about AI in a minute. Trade secrets. Trade secrets. So, I was told by Milo, who I bought a piece of apple pie for at Tate this morning, just to bribe him, because he was my guide, that the bells in the tower at Lowell were actually purchased when the wall came down from the east. And so it occurred to me to explain that if you were to try to manufacture those bells today, you probably couldn't do it. I mean, there's so many trade secrets that went into learning how to make bells that did not crack, that resonated at the right frequency, and that were of the right amplitude compared to the other bells. And all of that constitutes trade secret. So the important thing is many of the things that you will create for your enterprise are trade secrets. It might be your customer list, it might be your computer code, it might be particular documents that you have, your plan of action, your business model, your investor documents, whatever. So trade secrets are an integral part of your intellectual property playbook, which you all need to create when you're starting your company and then periodically go over again as you go forward. But important thing to know is people come to my office all the time and say, or I may meet with them and they say, don't worry, Rob, we're going to keep this as a trade secret, which is a perfectly legitimate statement, except for the fact that it probably is a hollow belief. Because in order to enforce trade secrets in court after they're taken, and they can go in many different ways, and one of the big issues often is a key employee leaves a company and in her mind, she knows everything. And you can't prevent her from getting her next job. But the question is, at what point in leaving, like taking computer files or whatever, does that individual step over the line and commit trade secret misappropriation, as it's called? So this is a very important thing because people are going to come and go in your company. You're going to have failed projects, joint ventures. You're going to have meetings with investors and others, and those investors may be trying to scope you out to figure out how they can either steal your company for a song later, we can talk about my paranoias, or whatever. So trade secrets are a very important concept. So what do you need? Well, it has to be commercially available, valuable. It can't just be anything, but a lot of things are commercially valuable. It can only be known to a limited group of people. Remember this, it can't be just general knowledge, because you can't take things out of general knowledge. That's the public domain, as we call it. So it has to be yours. You have to have taken reasonable steps. What are reasonable steps in this day of hacking, where governments and rogue organizations are hacking everyone? So is that enough of a reasonable precaution, even though you've been hacked? Do you lose all your trade secrets when you get hacked with ransomware or whatever? Big question mark. So the important point here is you have to be very, very vigilant about protecting your trade secrets, but you also have to be able to operate your business. You can't spend your whole life trying to protect stuff. You have to innovate as fast and as effectively as you can. But at the same time, you need to be careful about how you treat your most important information, your access to your most important documents. And that's a whole discussion that we could spend an hour about. So here are some examples. Batteries. Batteries are big because of electric vehicles, right? So two top Korean companies just had a huge fight at that International Trade Commission over batteries. We're talking billions of dollars of damage because one company accused another company of stealing their people and figuring out their battery technology, because we're talking about huge companies with huge sales. Now, scale it back to a startup. It can be just as devastating if one company steals the trade secrets of another small company, or if a big company steals the trade secrets from you. Google, we know all about self-driving cars. We've read about all these stories about, employees leaving one enterprise in Silicon Valley, where I spend a lot of time, going to another startup. This happens all the time. Silicon Valley, the joke is, if you get pissed off at your boss, you just walk across the parking lot to the next company and get a job in about a half an hour. And so when you walk across that parking lot, are you committing trade secret misappropriation? Technology agreements. You know, when you're starting a company, you need to be very focused on your collaborations. You need to be very focused on agreements that you have with your founders, because business divorces are actually worse than romantic breakups, because there's nothing in there for you other than pain and suffering and money. So you need to have appropriate agreements, and you need to be vigilant about your agreements. And there's all kinds of agreements. For example, joint ventures. You may do a due diligence. A due diligence may be done on you by friends and family, by your first investors, by institutional investors. You need to make sure that they don't just take all your stuff and pass it off to somebody else. I've seen this happen a lot. You need to make sure that all of your rights, we talked about this with copyright briefly, are assigned to your enterprise, because your intellectual property may turn out to be one of your most valuable, if not your most valuable asset when it comes to your end game, when it comes to selling your company or merging your company or taking your company public or taking some other company over or whatever you decide to do. And so when we put together an intellectual property playbook, as the professor said, I always ask the entrepreneurs, I say to you, what is your end game? What is your plan? Where are you going to be in 2 years, 3 years, 4 years? Are you going to just build this company up to a certain size and sell it? Because oftentimes startups are the engine of innovation in the United States, because big companies are chickens, big companies are greedy, and big companies don't want to take the risk. So they put it on all us entrepreneurs to create the new ideas, the new opportunities. They sit back with all their cash and they wait, and then they buy you for a song, maybe, if you haven't done your job right, or maybe for what you're worth, if you've done your job right. That's the end game, your liquidity event, whatever you want to call it. So the important thing here is you want to make sure that you have an inventory of your intellectual property and your intellectual property plan, just like you would if you bought a car, the title ownership, or owned a house, or whatever. Because remember, many people consider intellectual property to be property. Not real property like houses, not personal property like cars, but intellectual property. And remember the Constitution. It's your right, and it's secured, which suggests that it is already property that's being secured by these laws and federal agencies. So, one last point before we turn it over to the professor for all the fun, because I can't wait for the next part. But let me just tell you that in the last 24 months, and we were discussing this at dinner last night, I honestly think that more has happened in intellectual property globally in the last 24 months than I've seen in decades. In other words, the global intellectual property playbook has changed radically in the last 24 months due to geopolitical developments, such as the Ukraine war and now what's going on in the Middle East, or whether you were talking about a court that is now covering 17 of the European Union countries, including Germany, the Netherlands, France, and Italy. This court, after 30 years of discussion and planning and fits and starts due to Brexit and other things at the German Supreme Court, finally became operational on June 1 of this year. The Unified Patent Court allows you in one lawsuit to assert your rights against infringers in 17 countries in the European Union. It doesn't cover Spain and Poland yet, but it's over 500 million people. It's larger than the United States in terms of the number of people. And in a single action in this new court, you can bring a patent enforcement case, and it's cheaper and faster and frankly more predictable, in my opinion, even though we've only had 84 cases so far, than you would get in the United States with the IP world being what it is now. And I was involved and am involved in the very first case where in 110 days, a company out of Pleasanton, California, went against a company out of Seattle, Washington, in the area of spatial genomics. Company's name is 10x Genomics. They were able to bar this company out of Seattle using European patents from the entire 17-country jurisdiction in 110 days at a very low cost. And if you compare that to other countries, including the US, that is the speediest thing around. So what does this really mean? It means that you all need to get a basic knowledge of intellectual property for your own self-interest so that you don't have to rely just on so-called experts, but you'll know a lot about a lot, but you're not the expert, but you are the person who's going to ask all the right questions to your intellectual property strategist or your intellectual property trusted advisor or your intellectual property whisperer. And this is one of the most significant developments. And I can tell you that many, many lawyers that I know who are extremely prominent, when I start talking to them about this new court, we're talking US lawyers, they don't even know much about anything. I've told you more than most of them already know. So here are the countries that are covered by this new court. And you should understand that the new court only covers patents, utility patents. So you have to go to the individual countries to protect your designs, to protect your trademarks in Europe, and to protect your copyrights in Europe. So Europe, being Europe, is a complicated place in terms of how the legal systems of individual countries work in parallel with the European Union mechanisms. So there's a court, there's the Unified Patent Court, but there's also the European Intellectual Property Office in Alicante, Spain, which is not exactly the worst place to have to go. And that's where you register designs and trademarks in Europe. And as I said before, each country or each groups of countries have their own intellectual property regimes, and they either fit together well or maybe not. So you're navigating now not just the US environment, but if you're operating in Europe, or if you're operating now in the UK because of Brexit, the UK is out, you need to figure out how that's going to work. But again, this law is for you as entrepreneurs. So anyway, a couple of my colleagues, we have a very diverse firm. So I went to my experts, so I want to make sure you know that very little of what I told you is my original work. The work of authorship goes to these experts. So I'm going to turn it over to the professor now, and let's have a conversation, I gather.
All right, awesome. Thank you very much, Rob. We're going to do a fireside chat.
Okay. Right. Gotcha.
Can we get the screen blank? Let's see if this mic works. I broke something on it, but hopefully they won't make me pay for it. So I kind of want to talk about 4 themes with you. Let's start with maybe one of the more basic ones. We have students out here who are thinking about doing a startup. And so this is going to be them, maybe their roommates, maybe somebody from the business school, young people, got some ideas they want to go. What is the first couple of things that they should be thinking about for IP strategy as that startup, founders, small company?
Yeah. I find it very useful to write things down. In other words, you get your group together and you decide, what is it we're trying to do, Because if you can't really define in a short, say, one-pager, what is the business model? What is our focus? And what is our timeline? As I said, start with the end in mind, to go back to Stephen Covey's famous statement of his book about 7 habits of everything, remember? If you don't know where you're going, you're probably not going to get there as well. So I'm not saying you can figure that out at the beginning, with certainty or even anything close. But I think the intellectual activity of thinking through with your group as to what are we trying to do and how are we going to do it and what do we need to do it and who are we going to involve and what are our deadlines going to be, and just try to map out, and you're the pro on this, what is our business model? Because the intellectual property is going to be guided by your business model and the technology you're in. As I said earlier, the iPhone, people sometimes say there's 500 or 50,000 or 250,000 patents that cover the iPhone in some respect, right? So the point here is, if you are in that technology space of electronics, for example, or AI or big data or something like that, that's a different game than if you are in small molecules or if you are in artificial intelligence and so forth. So we only have one intellectual property system that covers all technologies and all business models. We don't have, a separate intellectual property system for the pharmaceutical industry and a separate intellectual property system for, say, electric vehicles. So the first thing I always tell people to do is meet with your team or yourself or your advisors and start trying to figure out on paper what it is you're trying to do. I think it's really important. It's not a comfortable thing to do because you feel awkward. It's like trying to write a term paper. Where do you start? Start anywhere.
So I think one of my takeaways is start with a business plan.
Yes.
And that should drive your IP strategy.
Right.
So let's just talk about a couple of the pieces that can be in your IP portfolio. And I just want to start with just a general question. What is an invention?
An invention is something tangible usually. It gets tricky with AI in the sense that, it can cover the functioning of a machine, for example. It can't cover just writing something down on paper. But if that happens to be on a computer system or electronically embedded in a dedicated system, that functionality could be an invention. It can cover the structure of the device. For example, there's hundreds of patents on all kinds of devices that you take for granted. And one thing that I didn't tell you, which I need to, is that each intellectual property right exists for a limited term, remember from what we saw? So for example, utility patents are only good for, say, 20 years, right? And then it goes into the public domain. And the reason for that is that exclusive right is the exchange that the inventor makes with the public for disclosing her invention in this written document, because the document has to be very detailed, as you know, because you're involved with patents too. And the important thing here is after that thing expires, everybody benefits from that knowledge. So, yes.
So imagine I'm in a startup, we've got a great new idea. When do I know I should go patent something? When do I know that I have something? And you can imagine we're somewhere eating pizza and I say, we could build a mechanical arm on my iPad. At what point do you think you need to start thinking, should I patent that?
Well, whether you patent it or not, and that's the question that we ought to go into in detail, is not really the question yet. The question here is timing. Now, the safe way to go is to keep your idea at trade secret until you have figured out your IP plan and implemented some basic moves depending on what that IP plan is. For example, I cannot tell you the number of times that people have come to me with fabulous ideas and I ask them the standard question, have you disclosed this to anyone? And they say, well, we wanted to test out the market. So what we did was we went to the XYZ show in this location, And we showed it to a limited number of people. At that point, my heart starts to skip a beat. And then they say, yeah, they promised to keep it a secret. But we didn't have any non-disclosure agreements. And, you know, we trust these people. And I say, okay, are they still trustworthy? Oh, yeah, they're still trustworthy. But, you know, and that was 11 months ago. Well, it turns out that in US patent law, if you don't get your original patent filing done within 12 months of something like that, you may have given away your rights globally, literally globally. So the important thing to know is that you need someone to guide you who is looking out for your best interest, not their best interest, we can talk about that, to tell you what you need to do before you start socializing this to potential investors, showing this to joint venturers, recruiting people for your team. There's a whole bunch of what I call IP hygiene that you need to engage in before you start running around trying to really spin the thing up.
Do you have any advice for young startups at a university looking to do something? Where would they find a trusted mentor or someone to help them develop this initial plan?
Very often, I get people referred to me and they say, look, would you be kind enough, Rob, to spend an hour with this, like I have one tomorrow with a woman that I've known for years, and she's got a daughter that's got a new idea. And so I've always subscribed to the idea that I give a certain number of these meetings for free, no matter whether the person goes forward or not. I don't know what a lot of my colleagues do in other firms, but as a founder who basically was befriended by some mentors, if you call them, who helped me out in a similar fashion over and over again, it's my give back, if you will, to them and to the community. So what I always tell people is you need to, right now, starting today, figure out who's going to be your IP mentor, your IP advisor, your IP trusted advisor. And it goes back to this whole idea of networking. And surprisingly, if you just look somebody up on the internet, used to be the phone book, but not anymore, and you look up intellectual property, or more likely patent attorneys, or intellectual property attorneys, you go to some law firm of any size, and they're going to charge you a consultation fee that might be several $1,000s. So what you need to do is figure out a strategy to find someone who's going to sort of joint venture with you at the beginning and not charge you anything, or charge you a minimal amount. And that's going to take some salesmanship on your part, for sure, but it's very doable because deep in their heart, most great intellectual property lawyers want to help entrepreneurs. They don't want to just represent big companies because they know from their experience that it's you who could be the next pick your company, right? So they want to get in on the ground floor too. But we can talk about various strategies that I've seen work, but the important thing is you need to build your IP advisor or network right from this day on.
Great. John Boyce will talk a little bit. He may have already talked in some of his lectures about IP. He's got an aggressive stance on it. He's one of the other instructors in the class. I think there's also some resources at the iLab for this, but I think, to me, it's just really important to understand that you have to have a strategy ahead of time.
Yes.
And he's correct. I've worked with several patent attorneys that have done it on a contingency or on a, it's not quite the word, they've written the initial application for free with the interest in being part of the bigger company going forward. And it does take a lot of salesmanship to do that. Speaking of salesmanship, I'm going to take this.
Oh, and can I make one point comment? I don't want to trash anybody needlessly, but there are outfits that you will see on various media that supposedly can either get the protection for you for a very low price or also provide technology transfer. And these outfits have been around for my entire career, and I got to tell you, when you really look at the stats of how many successful customers they have. It's like 1 in 15,000. So save your money. Go to a real person who knows what he or she is doing.
Great. I wanted to segue a little bit into your life, talking about salesmanship. So you got a degree in electrical engineering.
Two.
Two degrees?
2 degrees.
Got 2 degrees in electrical engineering, and that was at Tufts, and then you did your JD at University of Maryland?
Correct.
And so you graduated when you were 26, 25?
25.
25, took a job for a year.
Correct.
And then you suddenly decided, hey, the next logical thing is to go start a law firm. So take us back. You're 25, and what's going through your head in why you need to start a law firm and why that's the right step for you?
I love electronics. It's my hobby interest. Matter of fact, oftentimes I cannot believe I'm being paid anything to do my job. Because guess what? When you get to work with and work for and meet and collaborate with some of the geniuses of electronics and other technology spaces and get paid to do it, it's a gift. It's a total gift. And so when I'm down and out and feeling sorry for myself, David, I just pound myself on that thought and come right back, usually. But I was very successful because of my knowledge of electronics. And I was working for a firm in Washington that was the electronics firm in intellectual property law. And they represented satellite companies back when they were very rare, and major US companies like IBM and Ford Aerospace and Communications Satellite Corporation and Intelsat. So I was just working with the Bell Labs, if you will, of satellites. Couldn't believe it. So they had just opened an office in Tokyo because at this point, the Japanese were about to take over consumer electronics, which they did very successfully. And having lived in England as a little kid for 2 years, and having spent summers in Germany during engineering school, my bosses decided, okay, we have a gap of 4 months in the summer that I was sent over there, the summer after I took the bar exam. So I went to Tokyo, and I was one of 2 Americans from this law firm. I was the electronics person, and the older guy was the chemical. So I realized, I mean, I got along incredibly well with the Japanese colleagues of mine. They were very, very friendly and included me in everything. But the problem was I was 4 or 5 steps removed from the innovators, the inventors. Because the way it worked in Japan was the inventor, he or she, it was probably a he at that point, would submit the invention to a patent attorney in the company, who would then write up the patent and then turn it to an outside patent law firm, who would then turn it to a translation service. And then I would get this very rough translated version of this patent that I had to clean up and file in the US and around the world in English. And after a while, I realized, you know, I want to go meet some of these inventors. So I naively said I wanted to go meet this inventor at a very famous audio company. And they looked at me, you want to do what? They were very, very protective of their trade secrets. Now, I had visited many clients in the US because, you know, I'm a lawyer. I've got all kinds of legal obligations that I can't breach without losing my ability to practice law. So I assumed asking to see and meet with the inventors directly was just a perfectly legitimate request. Turns out it was not. And so they said, no, you can't do that. So on my way back from Japan, I was in Waikiki for a week trying to recover from being outside the US for a while. And I remember I was training for a marathon, and I was running 10 miles every morning at sunrise, just sort of chilling out. And I remember having finished a 10-mile run, David, and I'm dripping in sweat, the sun's coming up, and I said to myself, you know, if I go back to this law firm, I know I've done so well in Japan, I know there's going to be all kinds of pressure in order to make partnership that they're going to send me back to Japan. But I don't want to squander my interest in electronics. And there were other firms that wanted to hire me. and there were federal judges that wanted to hire me. But for whatever reason, being an obstinate SOB, I decided, my girlfriend's moved out on me. I have no student debt. Sorry for all of you. I got a shot. Now, looking back, I realized I always wanted to start my own thing. But, I was young. But for whatever reason, I decided to do it. There's a story behind that, but let's just say I decided to do it. And my parents were just completely flipped out. They said, what are you doing? You can't just quit a job. You have no money, you have no clients, you don't know what you're doing. And I remember my father, who was a newspaper editor at the time, saying, well, the worst that can happen is you can go bankrupt and get a real job, which, by the way, I didn't like that idea. So that was fuel actually, to drive me to do this.
And so what was the first success or so that got you rolling forward?
Well, remember I said that I really enjoyed my job. So I was constantly asking my bosses to give me assignments. I wasn't brown-nosing them. I just couldn't believe that I was getting to meet all these people that I was meeting. I wasn't trying to steal clients, because I didn't steal any of their clients from this firm, made sure of that. But I just love dealing with the inventors. I loved getting to know them, because all you inventors and you creatives, you're all different, but you're all the same. We can talk about that. But the important thing is, I just love the stories and the people. And so I had a boss in my very first job, this was the job, my summer job, who had moved on to Ford Motor Company. And they owned Ford Aerospace, which was a big military satellite manufacturer in Sunnyvale, California at the time, when there were apricot orchards in Silicon Valley. So they were amongst apricot orchards, if you can believe it. Not anymore. And so I remember getting a phone call right after I got back from Tokyo, and my friend Paul Godwin, who had now moved to Ford Aerospace, said to me, I've got two emergency projects that I need done in the next couple of weeks. I know you're just back from Japan, but you got to fit these in, Rob, because I need you to do them. I don't want anybody else to do them. And it required research at the patent office. That's all it did. And I said, Paul, stop. I can't talk to you about this, because guess what? Can't do it. He goes, what do you mean you can't do it? You too busy? I said, no, I'm leaving the law firm. He said, you've been fired? I said, no, I actually quit. He said, why? I said, well, I just want to start my own law firm and stick with high tech. And they're pushing me to go to Tokyo. Oh, okay, so here's what we're going to do. The first day you start this law firm of yours, if you do it, do me a favor and give me a call. So I called him, and he said, give me your address. This was a Monday, October 2nd. I remember it vividly, because that was my first phone call of the law firm, right? Back there, no cell phones. And he was in Dearborn, Michigan at the time, at Ford headquarters. And that following Saturday, 2 very formal-looking envelopes came in with Ford Motor Company in the top left-hand corner. And I opened each, and each of them, he says in this thing, your authorization is $1,500. Now, I was being paid $14,400 at the time. So to get $3,000 worth of work in your first week was not exactly a bad move. So naively, I thought I had made it until 6 months later, and we can talk about that later. But the point is, without him, thank you, Paul, I probably wouldn't be here today.
I think we talk a lot about serendipity and sometimes these events that help us get moved on to where we need to be. A question now for you is, you started up the firm. What was your strategy in building the firm?
A couple of things. Number one, we wanted to work for US inventors. Number two, we wanted to be on the absolute cutting edge of technology. Remember, that's all I had. I didn't have any legal experience. I was a year out of law school. I mean, that's a joke when it comes to being a lawyer. I mean, I was a quick study.
This wasn't your pitch to the inventors, was it?
No. I said to the inventors, I speak your language. I'm one of you. I just happen to be your guide into IP, right? And they loved it because after a while they figured out, he actually knows what he's talking about. But I only knew what I was talking about in electronics, right? Because I didn't know anything about, I'd taken chemistry courses, but biotechnology, what the heck was that? So I ran across a guy when I was getting my LLM at George Washington University Law School by the name of Jorge Goldstein, an Argentinian who had come to Rensselaer Polytech and then on to a school called Harvard, where he got his PhD and then did postdoc work at MIT. You may have heard of that school too, right? So I somehow, by begging and pleading, convinced him to join me too. And he was like the leader, represented this university, represented Mass General. So he really put us on the map in biotech. And the important thing is play to your strengths. Play to your strengths. You can get other people to support you and work with you and collaborate with you, but play to your strengths is what I learned.
I have a good friend who keeps on telling me not to leave the sandbox. And the metaphor is you have a play area that you do really well in, and that's an area to focus in. And I think that is exactly what you just shared with us. Let's look at one case, and why don't we do a bunch of balloons?
Okay.
Why don't you kind of talk us through that story a little bit so we can understand what the IP journey is and sort of what you've done in sort of a simple case study?
Right. So bunch of balloons, we looked at the trademark, but actually the patent is probably as important, if not more important, in Josh Malone's intellectual property story. Now, a little bit of context here. I represented, along with one of my colleagues who's actually worked with your professor, on a challenge to Josh Malone's patent at the US Patent Office after he had created an unbelievable sensation in the marketplace.
And he's the inventor of Bunch of Balloons.
He's the inventor of Bunch of Balloons. So a little bit of background about this guy. He is the father of 8 kids. He was an engineer for Texas Instruments, a very intellectually focused company in Dallas, Texas. He would put on birthday parties for his kids. A lot of them were very young at the time. And they would have water balloon fights in the middle of summer, because 3-year-olds love watching each other get drenched in water when they throw this balloon at each other and it explodes and nobody gets hurt. So he would spend hours and hours and hours. I've heard him tell this story many a time. And he would spend hours and hours and hours filling these balloons and trying to tie them off with his fingers, and it's just nerve-wracking. So he started trying to play things like, I'd hold the balloon and then I would take a piece of thread and wrap it around and then try to doing that with only 2 hands, right? So it occurred to him that if I had a bunch of nibs that started out wide and then narrowed down, and I put balloons on each nib, and there was an O-ring around the neck of the balloon, so that and all these nibs were connected together to this hose bib attachment that you saw. You just screw this thing on the hose bib, turn on the faucet, the balloons automatically fill together. They get to a certain weight, they slide off the nib, the O-ring collapses around the neck, and the balloon is sealed. Brilliant idea. Nobody had ever done it, because I can tell you we've looked far and wide for prior technology. Nobody had thought of this. And it was an instant success. And one of the characteristics about this particular product, it's fungible. So if you buy the average toy, you don't buy it again. But if you have a birthday party, you might buy 5 of these and consume them at that birthday party at $20 a piece. And then the next birthday party, you buy another 5 of these. So when you're dealing with your business model, you have to look at whether you are a recurring revenue business model or a one-off business model. Because investors are much more interested, I've found, in recurring revenue business models, as you know. So anyway, this product was an instant success. But before he announced the product to the world, he filed a provisional patent application. Remember, he was from Texas Instruments, very savvy company. He was an engineer. He knew their drill, thank goodness. Files this provisional, as it's called, patent application, which has turned out to be worth hundreds of millions of dollars. And then went up on Kickstarter, which was brand new, and announced this on Kickstarter, and he broke all records. He raised $1 million from 20,000 people overnight, and he launched the product. He got an exclusive licensee in the form of Zuru Toys, which has turned out to be a godsend for him and for them, because they had the manufacturing capability, they had the distribution capability, because he couldn't have put any of this together. He couldn't have raised the money to make these things and distribute these things. They instantly hit the market with a massive advertising campaign. This was before, a lot of sales on the internet. And overnight, the #1 infringer of great toys appears and steals the invention. And there's a huge court fight. He talks about.
Can I just pause here? Can you talk a little bit about what you mean by stealing an invention?
Okay. I know it's a pejorative word.
No, that's right.
happened.
It's just more of giving us a little bit more clarity. It's not like in the dark of night they broke into the company and stole it out of the safe.
So what they did was they went to one of the most prestigious law firms in New York City, and they looked at his patents, which they're totally allowed to do. And no doubt what they did was they figured, okay, #1, is there a way to come up with the same product, essentially, in terms of a balloon that would fill quickly, inexpensively, and be a consumable, without violating his patent claims, as they're called. The single paragraphs that you'll see in the patents, at the end of the patents, of the ones that I gave you the numbers to take a look at. So those are the single paragraphs at the end of the patent when you read them, and they define in words, in a single sentence each, what is the protected invention, as we call it, right? People spend hours and hours, days and days on this in intellectual property situations. So the ability to draft patents and get them through the patent offices is an art that some people are really good at and many are not. So anyway, I have no doubt what they did was they studied his patents, and they must have decided, well, you know what? We're going to have to come very close to his claims, or maybe over the line, and actually infringe the claims.
And just for a moment, this is really copying.
Copying, they ultimately did.
Okay.
But there's a process called design around. So let's say you want to compete with somebody else, and you have a better way of doing what they're doing. You may be able to design around their patent rights by getting somebody competent with you to help you and figure out what their patent really covers. The patent doesn't cover everything in the document, not even close. Most people say, my God, this patent is exactly on what I want to do. Wrong. It's what those claims, David, define at the end. That's the only thing it protects. So you have to do this forensic analysis of what the patent really covers. And you may be able to make some minor variations in your product design that from a legal point of view gets you out from under infringement. Or you may want to make a copy of it because that's the only way to do it.
And that's what this company did?
Yes.
And where did it go from there?
Huge court fight. I was not involved in the court fight. Big jury verdict, big recovery for Zuru and Josh. And then this company tries to take Josh's patent away at the patent office in a special procedure that I specialize in with the team. So that's when I get hired with the team. And we successfully prevent them from having his patent revoked. Because most people think, well, if I had gotten a patent from the patent office with this beautiful gold seal and ribbons on it, on the original document, I mean, that's my property right? But what you don't realize is that there's a procedure that comes as a shock to many, many inventors, that anyone in the public can challenge, anyone in the public, not just your competitor, can challenge your patent and basically say to the patent office, you should have never granted this in the first place. So that's what they did, and we were able to prevent that from happening. And then the rest is financial success.
Great. I want to touch upon in the few minutes we have left. We've talked about it several times, AI and intellectual property. And one thing I'd like you to answer is, why are AI created things, not inventions or copyrighted? And why are things that we create? And how can you ever tell the line between the two?
Good question. So starting in January, I've done a lot of face-to-face meetings around the world. And every company I've gone to, and there's been about 40 of them, regardless of the technology they're in, have asked me about AI. Because everybody's putting AI into everything, whatever that means, right? I mean, what is that, right? But AI, machine learning, big data, everybody's doing it. Everybody's doing it. So it's the #1 topic in IP right now globally. You may recall that we started the discussion with the Constitution and its authors and inventors. AI systems are not human beings. So they can't be an author or they can't be an inventor, according to US law so far. Because of that, even if you are running the machine, the output of the machine may not have been created by a human being. Now, in the UK and in Europe, they're obviously grappling with exactly the same issue, and they're coming out with different results. So the important thing to know is AI created things may be copyrightable, or they may be inventions that can be protected by patent in that country and not here. But right now, whether it be AI-generated pictures or something like that, or it could be a derivative work, where you take a photograph and you run it through AI. The taking of the photograph may be an infringement, but the output of that may not be protected by you. So as a general rule, you're probably not going to get protection if it's just a straight AI output.
Right.
However,
I just want to push back here a second. How do you know? I mean, maybe I am a good artist, and I really did paint that picture. Or I wrote my novel, and it really is a good novel.
Right. I don't know, because you would say, well, if I take my novel and I run it through AI, why am I not the author of the output of that novel? Right?
Right.
And I can't answer that question right now, because the thing you need to remember about intellectual property, and this is an absolute standard thought, is that the intellectual property world is always behind the technology and the business world. It's always behind. Because remember, we have one system for all technologies, and it has to cover all future developments. So it takes a while for the intellectual property world to catch up. And right now, this AI thing is the hottest topic going in AI, in IP law. So when you're going to your investors, for example, or your family and friends, you need to have someone who's really thinking about this as your IP whisperer to figure out ways that you might be able to get around this. We're filing on all these AI inventions, left and right. For patents, but we're taking certain steps to try to improve the chances down the line that we will have created rights that will be enforceable.
Okay, great. Let's get the QR code up. And while we're doing that, I'm going to ask you the last question. What do you wish someone had taught you or said to you when you were an undergraduate in college?
So there's a book written by a Wharton professor called Adam Grant called Give and Take. I don't know if any of you have seen this book. I urge you to take a look at it, please. The problem, in engineering school, we worked in teams, David, as you know, because you did the same thing. But when I got to law school, it was hyper-competitive. I mean, hyper-competitive.
You guys don't know what that's like, do you?
No, I'm sure you don't, not here. But in some schools, it's hyper-competitive. The problem with hyper-competitive is it's not the best strategy to have for yourself as an entrepreneur. So Adam Grant did a survey of successful business executives, and he found that there was a small group called takers who always made sure that he or she got more than they gave to other people. They were often the ones that were at the top of these organizations. Frankly, many of them are sociopaths or narcissists or worse, but they're on top. But the bulk of the population are matchers. And matchers, you know, I give you X, you give me Y. We don't keep a ledger, but we do. And so, you know, it's like quid pro quo down the line. That's the bulk of the population. And then there are the givers, the people that are always there for you, who always bail you out. They never get their own stuff done, and they always get at the bottom of the list. So people view them after a while as suckers. And then there's this small group called intelligent givers. I didn't know about this, who are more successful than the takers. And they always give more than they take. They give more than they take. They don't give less. But they're intelligent about it. They figure out, you know, over time, is this making sense for me and the person getting this? And the reason intelligent givers are so successful is they build huge networks of people. And if there's one thing I can tell you to do right now, is build your network. Get to know as many people as you can. Not all people are created equal, but you're going to need all kinds of people as you go forward to be highly successful. And you want to have a proverbial Rolodex that you can go to and get the kind of help you need when you need it.
All right, let's give a round of applause to thank Rob.